Hi everyone, and welcome to which I think is our last video for employee relations actually. So you've come this far, so well done. And once you've done this, that would be the end of outcome 1 for Unit 4, and only one outcome to go, which is pretty exciting. So we're looking here at conflict, types of conflict, and how to resolve that, so dispute resolution. Now the human resource manager plays a major role in that, or can play a major role in that. So we've gone through the role of the HR manager, and one of them is resolving conflict. So we're going to look at that. This is quite a bit of content here, which I didn't mean to, so I apologise for that, but there is a bit of content in this video. So conflict can arise for a number of reasons, and here's just a couple of them. So in the negotiation period, obviously conflict can arise if they're not coming to an agreement. The employees might go on strike or something like that, and that's normally over wages or entitlements or the work structures. This could be during negotiation period or outside of the negotiation period, where job security fears there might be action taken by a union. Often now it's type of managerial policies and discipline issues and those kind of things, or if there's any health and safety issues in the workplace, it might be that the workers walk off the job. So if it's a construction site and it's not safe, they might go, well, we're not turning up to work until things are fixed, so they'd work off the job. So they go on strike for that reason, they walk off the job. So they're just some of the reasons. There's many other reasons obviously, but there's just a number of reasons. Now, common types of action, a lot of these you would have heard of, some of them you mightn't be, but it's important to note that employees, most people think, right, industrial action, that's where employees are taking action against the organisation, and that is true, but employers can also take action against employees. And probably Qantas is one of the most recent major examples of that in 2013. Where they grounded their planes. So essentially employees couldn't work, which meant they couldn't earn money, because Qantas said, well, if you're going to take action against us, we're going to take action against you, and we're going to ground our planes so you can't turn up to work. So here's just a couple. Strike, which is probably the most common, where employees withdraw themselves from work for a period of time. That could be a couple of hours, it could be a day, it could be a few days. There's a lockout, that's where the employer, that's similar to the grounding of planes, where the employers actually close the workplace for a period of time. In the NFL, the National Football League in America, for gridiron, there was a wage dispute over there, and the clubs, I suppose, so the organisations actually locked their employees out, so they couldn't come there and train until the dispute was resolved. Picket lines, whereas a protest outside the workplace, they often try and stop suppliers or non-union members getting through. So non-union members might be trying to get to work and they stop them from doing that. Work to rule is where the employee actually works to the letter of the law, so they just perform their duties in their job description and nothing else. And work bans is where they refuse some form of work, so they might refuse to do overtime. Might be when the police decided to stop submitting the revenue for people speeding, so they stopped doing that. Now, is action allowed? So are you allowed to go on strike? Well, that depends. So written in law, there's a difference between what we call protected action and unprotected action. So protected action is any action that is taken by a party, whether that be the employee or the employer, which is approved by Fair Work Australia. Now, for it to be protected, it's got to go through a few things, but here's just a couple. So it's got to be voted in via a secret ballot. So that means that the members of the union get together, and a secret ballot means that no one, it's not just say, right, who votes yes and everyone puts their hand up. No one knows who votes yes and who votes no, so it's a secret ballot. And a majority have to actually agree to the action that's going to be taken. Then the organisation or the other party needs to be notified 3 days in advance. So this is really typical for a strike. That's the process that goes through. Now, Fair Work Australia can actually put an end to any action if it's going to affect the wider community or the economy. So if some action is going to, affect other suppliers or anything like that, other businesses, then Fair Work Australia will step in and put a stop to that. That happened in the Qantas case where there was a strike and then there was the grounding of planes, and Fair Work Australia said, no, that's it, no more action. And then unprotected action is unlawful and damages can be sought in court for unprotected action. So in terms of resolving conflict, there's 5 things that we use. When a dispute arises, it's important to resolve it quickly, and so the 5 ways. The first one is a grievance procedure. Since enterprise bargaining has been implemented, most organisations, especially large organisations, have a grievance procedure, and all that is just a step-by-step process of how, if you've got any kind of dispute, especially when it's an individual type of dispute, that you can actually lodge a formal or informal grievance, and then it's just a set of processes that go through to get that resolved. And it could end up with mediation or something like that. Negotiation, we know what negotiation is, so it's essentially discussing with each other ways of resolving a dispute. So that one's pretty straightforward. And then we get into mediation, which is where a third party actually comes in and facilitates the conversation between the two parties which are in disagreement. Essentially, it's important to note here that in mediation, the parties come to their own agreement, and the third party doesn't normally have any involvement other than facilitating the conversation. Conciliation is very similar to mediation. However, so there's a third party involved again. However, the third party has a little more power. Fair Work Australia often does conciliation, but it doesn't have to be Fair Work Australia. And so what happens is that the third party might say, righty, you've got to go away for 2 weeks and negotiate and then come back on this date. So they can actually make orders for the negotiating parties, and they can also make suggestions. Those suggestions aren't binding, but they might make suggestions for either parties on where they can compromise. Arbitration is taking it to the next level. So that's that picture there's of the Qantas CEO, where they ended up going to arbitration to resolve their dispute. And that is where both parties put their case forward to a judge, and that judge makes the final decision, and it's Fair Work Australia that normally deals with that. So that is, I suppose, the most serious, because organisations normally want to try and avoid that, and employees and unions try and avoid that also. So it's often a last resort, because essentially you might come out of there and both parties aren't happy because the judge is making the final decision, and that final decision is binding by law, so it must be abided by. So they're our 5 ways of resolving conflict. And just to recap, remember, industrial action can be protected or unprotected, and resolving conflict, there's 5 things that we can use. So in an organisation, there can be a grievance procedure, and then there's obviously negotiation, and then after that, we have mediation where the third parties are involved, mediation, conciliation, and arbitration. And for all the questions and activities for this video, go to teachingbubble.com.